are live.
Hi everyone, thanks for joining our live stream today. If you have questions, feel free to post them in the chat. We'll definitely get to a lot of questions today if everyone has them. I did want to talk about both EB1 and NIW profile building from a little bit of a different perspective today. I work with a lot of clients who unfortunately have relied on the perm process, got to the end and got denied for some reason, or who were stuck in a perm process and then it failed or couldn't move forward, or who got laid off from their job. Like there are 100 different things that can happen that cause issues with the green card sponsorship process. So I work with a lot of people who are at the very end and need an immediate solution. The immediate solutions are usually file the NIW to preserve the H1B or to file the EB-1A if a child is aging out. There are definitely a lot of people in circumstances where they don't really have time for profile building. They don't really have time to make the profile as strong as possible. They need to file ASAP. I do file those kinds of cases as long as you have a viable claim, a reasonable argument. You can put that forward to USCIS, and I'm happy to represent you and take it as forward to the highest approval chance as possible. I do know there are other attorneys who don't take those kinds of cases because they just don't feel that the person is qualified enough or has a high enough chance of approval. And, there is some, there's good intentions behind that. Like they don't want to take on a client and waste the client's money, time, resources, and all of that. They don't want to have to deal with a denial. But I do take those cases if the person has a real valid justification for why they need to file a case. If you don't really have a strong case and you have time, I'm going to be telling you to build your profile. Like there really isn't a reason in a lot of cases where you can't wait 6 months, make the case a little bit stronger, and then proceed with the case after those 6 months. So no one should feel really, really rushed in this process, except when there are circumstances that require that kind of rush. So when I do work with clients who are right up against the clock, where we have to file the case and maybe we have to start prep on the case now and file in 2 or 3 months, I still recommend some profile building activities, just so that when we do file, you are presenting the strongest case possible and giving yourself the maximum chance possible of either getting that NIW approved for the H1B extension or getting that EB-1A approved so that your child can then proceed with the green card process. The highest value activities that you can do in a short amount of time are the kinds of activities that raise your profile and raise your acclaim within the field. You want as much outside recognition of your accomplishment as possible. So if your profile is lacking in criteria for an EB-1A, for example, if you are only claiming 3 criteria and you really can't claim anymore, you should probably try to get a 4th criteria in the next couple of months. And sometimes that does mean lower value activities like judging a couple of hackathons if you need to add judge. Sometimes it might mean like getting a couple of media pieces, even if they're not the best quality media pieces possible. So sometimes you need another criteria. But if you're looking at it from a final merits perspective and trying to see what's going to move the needle, that outside recognition is really, really important. So oftentimes I'm having you focus in on membership, even though that's a hard criteria to win. If you can get appointed to some kind of committee, commission, board, something where a bunch of experts are acknowledging that you are also a top expert in this thing, that looks really good for your EB-1A case. And so if you have any opportunity and if you can network and get that kind of position, it's very helpful. You can also look at speaking engagements at this stage, and not just any speaking engagements. You would need to be able to speak and be acknowledged as an expert by a really reputable conference or a really high impact event within your profession. You would want your other panelists to be really top experts if you're on a panel, or you would want to be the keynote speaker for a huge or a major event. So you can profile build that way as well, especially if you don't need another criteria and you just need to build up the final merits. On the NIW side, it is a little bit different, but also the types of things that I recommend are pretty much the same. So, in the NIW context, often people are working with a scenario where they don't have anything done outside of their company or outside of their 9 to 5 job. In that case, I'm recommending just join associations. Like in the EB-1A context, you need to be on like a top panel or commission or committee. But for the NIW context, you just need to show that you have an outlet to contribute to the broader field and the broader industry. So just joining associations and participating in one event or becoming a volunteer for one of their like regular roles, even like events coordinator or new members coordinator, some kind of role within the organization is really, really good. So I would strive to get that as soon as possible. And then for NIW, lower quality publications are accepted. So if you can get an article written and published in one of the online publications that doesn't necessarily go through peer review, but just has like an editorial approval and review process, that's also really high value for your NIW. You want to be able to show that you are putting your ideas out there, that you are contributing your time, that you have energy and passion for pursuing your proposed endeavor. And so those two are probably the highest value activities you can do for NIW. And then also speaking engagements are great, just like with the EB-1A, the higher level, the higher value the speaking engagement, the better it's going to play for your NIW case. So yeah, if you are filing right away and you have a weaker case, still try to do some profile building. Just pick opportunities that you know are going to pan out faster. And then among those opportunities, pick the highest impact ones that you can. Choose the activities that are generating the most acclaim and would be the most recognized within your field of expertise. I would not let anyone discourage you from trying for one of these categories. In both NIW and EB-1A, sometimes weak cases get approved, strong cases get denied. If this is the difference between you staying in the US and working in a job that you really love or having to relocate and go back home, it is perfectly fine to pursue a weaker NIW or a weaker EB-1A. You don't have to feel bad about that. You do have to meet the requirements. Like no one should be filing a case that is totally frivolous. That is actually unethical for attorneys to do as well. So don't go with any attorney who says, oh, you meet 2 EB-1A criteria, but we're going to file this anyways just to extend your stay. Like definitely don't do anything like that. But you can give yourself a chance if you really, really need to take that chance in a short amount of time. All right. So that's just a quick overview about quickly filed cases or super fast profile building. To talk just a little bit further on an adjacent topic here, too many people are putting too much pressure on themselves to build the EB-1A profile within a very short time. And in doing so, they're looking for major shortcuts. Now, it's fine to set goals for yourself. It's fine to push yourself. You actually should do that when you're doing EB-1A profile building so that you are actually building momentum and making sure that you are on track. So, goals and aspirations and timelines are fine. But if you are putting too much pressure on yourself and saying there's no other option, I will get this done, you will probably end up considering a lot of opportunities that are pretty sketchy because those are the ones that pop up. That's what's readily available and immediately available. I would caution you not to do that if you don't have to. It is very reasonable to set a profile building timeline and goal for 1 to 2 years in the future. A lot of you will be able to do it in 6 months, but only if you already have a really strong foundation to the case. I see some people who say they're going to do profile building in 1 month or 2 months, and that never happens, not even for really, really strong cases. If you're doing profile building in a matter of months, guaranteed the opportunities that you're getting are lower quality. It takes time to network. It takes time to apply for things. It takes time to get those opportunities that are higher quality because they require a lot of vetting. And any opportunity where you apply and the next day you get in, it's not always lower quality. Sometimes the timelines just work out that way, but on average, they tend to be lower quality. So just be careful. Don't put too much undue pressure on yourself. make it realistic. Like, keep a pace that you know will motivate you, but that will also give you enough time to find those higher value and those higher level opportunities. Yeah, I come across a ton of people who say, I'm going to file in 3 months. And I look at the case and I'm like, 6 months might be possible, but you would have such a good case in a year. Don't be afraid to do that. Like, don't get too wrapped up in the hype, so that you are taking too many shortcuts and ending up with a weaker case. All right, we can go into questions. I think there are a couple here in the chat.
Hello, can reference letters from early stage startup CEOs, not employer, be helpful in the EB-1A petition as the third party and related referrals?
Yes, so they are very helpful, and they can be very good for independent references. It is always good to be able to explain, like, why the startup CEO is giving you the reference. Independent references don't need to be so independent that you've never met the person. They just need to be from a person that you haven't worked directly with or collaborated directly with in the past. So I actually think reference letters from people who are in the same membership organizations as you are good. Like, if they met you at a networking event, that's also good. If you find some random startup CEO who doesn't know you and you've never had any interaction with in the past, I think I would ask why. Just because the startup CEOs aren't the type of people that people normally reach out to for references. It's a little bit different when a professor issues a letter, or something like that. So yeah, I think if you want to post more information about this, I'm happy to dive into more of the details there. But I do routinely submit letters from startup CEOs.
What kind of policy tightening can one expect on existing H-1B workers, like salary increase, etc.?
Yeah. So there is an H-1B regulation in the works. We haven't seen the final language from it yet, and I just looked right now on the call, because I saw some news come out this morning. I still don't think it's been published. Yeah, I'm not seeing that it has actually been published yet, so I can't actually provide an analysis of what it contains and what it does to the program. I do know they're going to try to shake up the lottery process so that the lottery is more weighted towards higher wage jobs. But I don't know that it's going to include restrictions on existing H-1B workers. There was a regulation that they tried to pass during the last Trump administration that would change the wage scheme. And it would have actually resulted in significantly increased salary requirements on existing H-1B workers. I think that regulation fell through procedurally. I don't remember the full reason why. So I don't know if they're trying to do the same thing in this regulation. The analysis should be able to come out soon, because I think it just cleared the next stage of the approval process. And so I would expect that the agency publishes it in the Federal Register very, very soon. And once it's published, we can do the full analysis.
Why doesn't my NIW case appear in my USCIS online portal while I do have other past OPT cases there?
The USCIS online portal is kind of a mess. The NIWs and the EB-1As and a lot of the I-140s don't appear on the portal because they're not linked to the electronic system. They're considered paper cases. And there isn't really much you can do to add the case if it's not there. Now, you're still going to get paper notices, and sometimes you're able to sign up for some text notices and things like that. But you just won't have the full functionality that you did for the OPT.
Don't see any other questions.
Mm-hmm. All right. Let me think. So for EB-1A, just another note on profile building. We can continue talking about profile building since that's kind of the theme that we sent up at the beginning of this live stream. For profile building, a lot of people are asking how many criteria they should target. And I have seen a lot of cases that are put together both by individuals who are doing the profile building where they target 8 criteria. And then sometimes I'm seeing the way cases are put together by other law firms and they're claiming all 8 criteria. I would maybe caution against that strategy. I have encountered some cases that are very successful with the 8 criteria strategy, but I've only filed maybe 3 or 4 of them in the past few years. You definitely do not need 8 criteria. And in many cases, when someone comes to me and they're trying to claim that many, 3 or even 4 of them are no good. Like, they're just not strong at all, and they will trigger and raise questions if we submit that information to USCIS. So you can pick and choose. Like, just because you have an award doesn't mean you need to include it in the case. Just because you have a couple media publications doesn't mean that you need to include them in the case. Make sure that whatever you're putting together and presenting to USCIS is portraying you as a top professional and makes sense in the overall narrative of things. Now, sometimes I do include criteria that are weaker. It's not always a bad thing, but if you're claiming so many criteria, you might as well focus on the strong ones and not the weak ones. It does present overall as a stronger case when you do that. I'm also seeing a lot of other law firms or attorneys present the criteria in the order that they appear in the regulations. So they're always covering awards first, and then membership, and then media, and then so on and so forth. And I understand that that's like the normal firm template, and many of these firms have had success with that in the past, so I'm not saying it's totally wrong. But I do think it's odd in a lot of scenarios. Like, I had a consultation with a client this week, and this client had a case that had been put together in criteria order. I didn't know anything about this client when I came onto the meeting, but they wanted me to actually review the petition letter on the call session with them, which I'm happy to do. I don't do case reviews in advance, but I will always review documents on the call with you if you would like to do that. So I was reading through the case, and then it didn't have much of an intro summary. It dove right into awards, and then media, and then membership. And I'm reading through the case, and I'm like, this award, maybe it's good, maybe it's not, but not probably extraordinary. Media, these are okay. They're not bad. They're not fraud, but really strong, no. And I get 3 criteria in, which is like a quarter of the way through the case, and I'm like, I don't see how this person is extraordinary at all. So I'm getting really kind of annoyed, I think, because I'm not understanding why this is an EB-1A. So then I asked them, okay, what is your job title and where do you work right now? And they were principal level at a Fang & Company. And I'm like, oh, okay, you are extraordinary. Why isn't that front and center? Like, why isn't that at the top? Why isn't it the number one thing that is being pointed out in this case as you being someone with extraordinary ability? So the presentation matters, and how you use the evidence, what criteria you claim, and in what order you claim them does matter as well. Make sure that you're not just going with a firm that's following a template, but that they're actually paying attention to the narratives in your case and why you qualify. I think that's very, very important. All right, we can go into more questions here.
Applied for EB-1A. I met 6 criteria, yet I was denied because the officer considered that since I moved to the U.S. 6 years ago, not maintain the same level of success as in my country of origin. Not sure if I should reapply. I currently hold an E2 visa and apply for an NIW.
Yeah, so this is always interesting. Whenever someone has a really successful career abroad and then they come to the US, I mean, usually they're coming for an MBA or some other kind of study. And I talked about that on our live stream a couple of days ago. But it sounds like you actually came on the E2. USCIS does definitely consider that to be a break in your career at times. And so if you had a really successful career and then you come to the US and now you're in what will be considered a lower level role, or you've pivoted and changed your career into a kind of a different direction, USCIS won't always let you use that past experience in that really, really successful career abroad. If you pivoted, they might say, well, you're kind of in a different field now, so we're not really going to take all of that prior experience into account. And then if you've just graduated, I think there does tend to be some kind of bias against students or recent grads where they just aren't seen as being at that high level, even if they did have a really extraordinary and successful career in their home country. So it's just a bias at that point. So it's hard. If you find the same level of success in the United States, it's definitely going to be easier for you. So some people do need to wait a few years and build that up before they can reapply. Now, you said that you're holding an E2 visa, so I'm assuming you came over through the E2. If you are an investor and you're really involved in setting up this company, it can be good for the NIW because NIW, one way that you can qualify is showing economic impact, job creation, overall benefit to the United States in all of those factors. And that actually works really well with the E2 entrepreneur visas. If you're an E2 employee, though, it becomes a lot harder. If you're in an E2, executive role where you're directing the operations of the business, there might be some argument there for leading or critical role as a criteria. But if you're E2 specialized knowledge employee, it is quite a bit harder. So you have a bit of an uphill battle there. One thing you should know, like it is possible to go from E2 and then apply for the NIW, but it's very, very important for me to emphasize here that the E2 is a single intent non-immigrant visa. So if you're looking at applying for the NIW, you do need to have an understanding that that's just to open up options for your future. You shouldn't really hold an intention or a plan to transfer from the E2 to a green card holder or green card status. You should always have plans to relocate back to your home country. You should always be prepared to purchase a plane ticket. You should be maintaining your ties to family, career opportunities, property, bank accounts, that kind of thing in your home country. It's very, very, very important. So yeah, you can look at NIW for the future, but keep those plans kind of loosely held and make sure that you're maintaining your ties at all times.
How's the H1B NTA situation going on?
I mean, it doesn't seem to be too disastrous. Like, there hasn't been a huge influx of these NTAs being issued. I will have to go back through my notes and see if I've heard chatter of anything being issued in the last week or so. I do know there have been a lot of successful dismissals in immigration court. There's chatter about class action lawsuits. I think everyone knows it's just a huge waste of government resources. And so I am hoping that it's going to calm down. Now, that doesn't mean NTAs themselves are going to calm down. I think USCIS is trying to figure out how to issue more NTAs. It's just I don't know that this is going to be continuing as a really bad situation that needs to be addressed for H1Bs specifically. There are tons of groups that USCIS can target outside of H1B, and I think that they chose like the most frivolous one to test this out on. It's very, very silly. So yeah, I mean, I haven't heard any increases, influx reports of that. I'm hoping that it's settling down, but maybe I'll have an update in a week or two. We'll see.
For the EB-1A critical role criterion, does the work I perform need to show benefits to the general public in the U.S., or is it sufficient if the role had a significant impact just on my organization?
So the critical role is specific to your organization. You do need to show that your organization, though, has quote unquote distinguished reputation. So usually you are showing that your organization has a huge impact on the US and that your role has a huge impact on the organization. So you're making a roundabout argument about your impact on the US as well. Or if you're not in the US, you're making a roundabout impact analysis on whatever country your company is located in. So yeah, just be able to explain the ultimate impacts of your work at all times. Even if it's not supposed to be the focus of this criterion, it's still very, very important.
This is from the last question.
Yep.
Are your USCIS or denying applications for form oversights?
Yeah, they're definitely bringing that back. Very, very frustrating. The Department of Labor is doing that as well, although the Department of Labor has always been a little bit more of a stickler about that. It's just the new normal for the agency. They've definitely pivoted hard from being more of a service agency, which is trying to process applications in a reasonable and timely manner, back to an enforcement focused agency where they are really trying to figure out reasons to disqualify people and exclude people. That shift, that fundamental mission shift, impacts everything. And I wish they would go back to more service stuff, because so many immigrants here in the US are trying to do the right thing through a very, very complicated system and complicated processes. We don't really want USCIS to be the new DMV. It's very, very frustrating that they're kind of adopting that mindset, that enforcement or bureaucratic mindset. But it is very intentional. So I think during the rest of the Trump administration, this is what we're stuck with.
Is it necessary to have experience in an industry in which you have PE? Like in tech, a framework that could safeguard data could be applied to multiple industries?
I mean, you don't have to define an industry in your personal endeavor statement. You could define it as an occupation. You could define it as a field. There's not a real requirement like that for NIW. So you can talk about multiple industries. You can talk about one industry. You should make it broad enough, though, that it's going to cover your future career activities so that you don't have to file an amendment or refile a new EB-2 NIW, 2 years later when you pivot into a different industry.
Denying cases over signatures, troubling new trend. USCIS is issuing RFEs and NOIDs, claiming signatures are deficient, sometimes denying applications entirely, despite its own policy allowing.
Yeah, it's definitely happening. So there have been lots of reports over denied cases on the basis of signatures, which again is all very, very silly. Like, we should just have digital signatures. There's not really an excuse for why we don't have digital signatures today, and why USCIS wants us to print it, sign it, scan it, retain a copy of the signed copy, and then send them the scanned copy. Like, it doesn't make any sense. And it seems like they're just trying to impose additional reasons to deny the case. It really doesn't make any practical sense at all. But it is a thing, so be careful.
You've worked in fintech, proposed endeavors in healthcare.
Yeah, I mean, you would want to use one or the other. Using both is tricky. But you could use both if you're focusing it more on the occupation level. So if you are a data scientist and you're currently working in fintech, but if you are a data scientist and you want to transition into healthcare and have your proposed endeavor around healthcare, you need to focus more on the data science part and less on the industry. This is possible. It's always advantageous if the case kind of narrowly focuses in on like the more narrow, the better almost. But sometimes that's just not possible given your set of circumstances. So you can go broader if you have to. I would want to talk to you about this individually and what the strategy would be.
Last question, how to set up time for an assessment, next steps on EB-1A profile building.
Yeah, if you want to book a consultation through my website, I would be happy to talk to you about EB-1A profile building. I do a lot of that, and those are my favorite kinds of consultations. So feel free to book that. All right. Thank you so much, everyone. I appreciate you joining the live stream. We will talk again next week. It's almost the end of summer. I can't believe it. But if you do want to schedule some one-on-one time, please feel free to book a consultation through my website. All right. I will talk to you all later.